Hey guys, I got some bad news. The NFA won in court today. Kind of a backdoor way. But I think we need to talk about this case because a lot of people have been waiting for this case and to watch how it progresses. Wasn't good today. Before I jump into that, I want to thank the sponsor of this video, and that's Lear Capital. Guys, the United States is broke and it's just going to keep on printing money, which is why you and I have to do something to protect our savings. That's one of the reasons that I buy physical gold and silver from Lear Capital. They ship it directly to my door in just a few days, and they can also tell you how to protect your retirements by adding gold to your 401ks or IRA accounts. Head on over to LearGG.com or call 1-800-260-5075 and get your free investor guide. With a Google rating of 4.8, over $3 billion in transactions, and over 90,000 happy customers, they'll be sure to help you start to protect your investment and your retirement with gold and silver. Once again, check them out at LearGG.com or 1-800-260-5075. Thanks to Lear Capital for being a sponsor of this channel. Hey guys, my name is Jared. This is Guns and Gadgets, and I bring you Second Amendment news every single day. Good, bad, ugly, or indifferent, no matter where it happens in this great land, from litigation to legislation and everything in between. And today I'm going to tell you about a case we've been watching out of Texas, and that was related to Texas's Suppressor Freedom Bill. Everybody was excited about this because it was Texas challenging the unconstitutional, it's unconstitutional obviously, but the unconstitutional registration and taxing of people who want to make suppressors. A judge dismissed the case today. Dismissed it without prejudice, which means that if Texas or the individual plaintiffs really want to push this, they can. But I'm going to read you some of the things that the judge said, and then we'll be right back to talk about that. Let's start here with the regulatory scheme. The National Firearms Act, passed by Congress in 1934, as amended by the Gun Control Act, passed by Congress in 1968, regulates the possession and manufacturing of firearm silencers or suppressors under 26 U.S.C. 5845. To make a silencer for personal use, the Gun Control Act requires individuals to file a written application to make and register the silencer, identify themselves and the silencer they wish to make, and pay a $200 tax. Applications to make silencers must be approved before the applicant can make the silencer, and it is a crime to possess an unregistered silencer or make a silencer in violation of these procedures. Applications to make and register silencers are denied if approving them would cause the applicant to violate another law, i.e., if approving an application would result in a convicted felon's possession of a firearm. That much we know, right? But I start that because some people who watch videos don't have that knowledge. Now we know what's being challenged. Here are the parties. Fleos Allen, Tracy Martin, and David Schnitz are the individual plaintiffs. They're citizens who wish to make silencers at home without filing an application or paying the tax. They allege that it violates their Second Amendment rights for the federal government to require them to seek permission and pay a tax to make a silencer at home for personal, non-commercial use. And I agree. Plaintiffs also allege that they do not intend to make their silencers from any major component part manufactured outside of Texas. That they intend to own these silencers in perpetuity, which means forever, and that they seek to make them for the exclusive purpose of home defense. But plaintiffs have neither alleged that they in fact possess an illegal, non-registered silencer, nor that they have attempted to complete the application to make one or paid the tax. So the court's saying, you didn't even try to make one. You're not telling us that you own one illegally. Well, yeah, that would be self-incrimination. So we don't think you have standing. It gets better. The state of Texas joins as a plaintiff to vindicate what it sees as its quasi-sovereign interests in its residents' ability to make silencers at home uninhibited by federal regulation. Texas alleges that its residents' physical and economic well-being are at stake because making and use of these silencers would protect an individual's ability to hear would-be home intruders and improve their ability for self-defense. I agree with that. I mean, that much is obvious as well. So standing is something you have to have in order to sue. And if you don't have standing, you don't have a case. Listen to this part. Under Article 3 of the United States Constitution, cases or controversies only exist when a plaintiff has standing to sue. Standing has 3 basic requirements. First, there must be a concrete injury, in fact, that is not conjectural or hypothetical. Second, there must be causation, a fairly traceable connection between a plaintiff's injury and the complained of conduct of the defendant. Third, there must be redressability, a likelihood that the requested relief will redress the alleged injury. Here, the parties only contest whether plaintiffs have suffered an injury in fact. The court, therefore, cites its analysis on that element. So I'll break this part down for you. I'll surmise it. The court is saying that, you don't have these items, at least you're saying you don't, and the fact that you want to make one doesn't actually put you at risk of being persecuted or prosecuted. They're saying that you also weren't threatened with prosecution should you attempt to make these, which actually is a lie, because if you make a suppressor without going through the NFA, the ATF definitely will go after you for 10 years in prison and $250,000 fine. Of course, if you're found out having one of those. So yeah, you face a decade in prison if you do this. Then after shredding the individual plaintiff's standing or lack thereof in the court's opinion, the court targeted Texas. The state of Texas has no Second Amendment rights of its own. Thus, Texas alleges that it has standing to defend its quasi-sovereign interest in the health and well-being, both physical and economic, of its residents in general. Texas claims a quasi-sovereign interest in protecting its residents' ability to make silencers free of federal regulation, specifically for plaintiffs' ability to diminish the need to obtain and use hearing protection in the event of a home invasion. The parens patriae action allows a state to sue on behalf of its citizens at large, but it may not do so against the federal government. And the court then alleges that Texas is relying on an old Massachusetts case, Massachusetts versus EPA, and the greenhouse gases lawsuit. And they said Massachusetts could do that because the air and all that stuff would affect its sovereignty if people started to get poisoned and stuff like that with the air they breathe. So Massachusetts could do that. But to sue to protect the Second Amendment, oh, you can't do that, Texas. It says Texas does not seek to protect any interest remotely akin to the earth and air within its domain. That was the Massachusetts case I just talked about. Nor does Texas allege that it has any concrete or imminent injury specific to the state or its administration. And we'll jump to the conclusion here. Under Article 3 of the U.S. Constitution, cases or controversies only exist when a plaintiff has standing to sue. And a party's dislike of a federal law does not give them standing to challenge it, because neither the individual plaintiffs nor the state of Texas have standing. There is no case or controversy before the court. Therefore, this court grants defendant's motion for summary judgment and denies plaintiff's cross motion for summary judgment. The court further orders that this case is dismissed without prejudice. And this is Judge Mark T. Pittman of the United States District Court for the Northern District of Texas, the Fort Worth Division. So this is a case a lot of us were watching because although Texas, Governor Abbott signed this law, it was put on hold because it needed to pass the scrutiny of the DOJ. It needed to make sure that it was akin and aligned with the Constitution. And this judge is saying, you don't even have standing to sue. So we're not even going to get past that. This isn't good. I don't know if this judge expected these individual plaintiffs to make suppressors, get pinched by the feds, and while they're serving their decade in prison, then sue, then they have standing because they were actually injured, legal injury. I don't get this judge where he's coming from, because challenging the constitutionality of laws, you don't have to be injured. Just the fact that your civil rights are violated should be cause for standing. I don't know. Maybe it was the way the case was presented. Maybe it's just this judge. I don't even know this judge is appointed by a Democrat or Republican, but apparently this judge wanted no part of being the judge that led to the destruction of the NFA, specifically the silencers and suppressors portion of it. Big step back here for Texas. I'll let you know if anything happens as far as if there's going to be a murmur about an appeal. Guys and gals, my name is Jared. This is Guns and Gadgets Second Amendment News right here every single day, no matter where it happens. My goal is to hit 650,000 subscribers before my birthday on July 25th. Still time to do that, but I'm going to need your help. If you could, just hit that subscribe button down below. Like this video, share it. More people need to know this, because a lot of people who want a suppressor don't want to have to go do that registry thing, nor do they want to have to pay a $200 grant me the okay to make this daddy fee. So yeah, bad decision. See you on the next one. Take care.